precedent for nation building. Unfortunately, every step of the removal process being undertaken against me is being done in a manner that breaks every rule on how justice is delivered in our country. And this is why I find the need to draw the nation's attention to the serious violations of the Constitution and law in the process, and the danger it holds for the development of the nation's democracy. The second reason for making this statement is, though I'm in the process alone, its effects ripple far beyond me as a person. This process will affect how all Superior Court justices and future Chief Justices perform the functions that indicate able to perform the functions of my office. An example is an allegation that I failed to retire accountable interest of $14,000 when I traveled. When I did retire that accountable interest 2 days after I returned from my journey, I was given $14,000. I could only spend $4,400, and I returned $9,600 2 days after I returned from Ghana, from my journey. And so I knew that it was necessary that the issues being thrown around as petitions against me needed to get into the public space. I swore to a supplementary affidavit alerting the Supreme Court also of human rights violations that I had started encountering when I went to the Article 146 hearings. However, the members of the Supreme Court that heard the application refused my application for the hearing in open, and they also struck out the supplementary affidavit at the request of the Attorney General. I have decided to make this statement today because the violations have not stopped. Indeed, they have escalated beyond anything I could have imagined as possible in justice delivery. These violations include the committee's refusal, in breach of the rules of natural justice, to recognize my lawyer on the first day of proceedings, simply because I was not personally present with him. And they went ahead to make arrangements for the hearing without involving my lawyer while he was sitting in front of them. The committee has also failed to indicate the specific charges that I'm supposed to be defending myself against in order to allow me to adequately prepare a defense to the charges. The committee has gone on to permit two of the petitioners, Mr. Daniel Ofori and Shining Stars, not to testify at all or present what case they brought to them at the hearing. The committee has refused to allow me to go into the hearing with any family member. Before you enter, there's a thorough search of my body and my handbag in violation of protocols and courtesies extended to any Chief Justice, which protocols and courtesies are honored in the name of the nation, both in Ghana and outside of Ghana. And then the work of the committee is being conducted in a cordoned high security zone on Castle Drive, Osu, when all Article 146 proceedings since 1993 have been held in facilities of the Judicial Service. It is hard not to reach the conclusion that the choice of venue against the backdrop of secrecy of proceedings is intended to intimidate me and to prevent any citizen of Ghana from knowing how the proceedings are being conducted. The Edu Lodge facility that the hearings are being conducted in featured very prominently in the planning of the murder of judges on June 30th, 1981. And this can be read about in the special investigative report on that terrible event in our nation's history. It will be recalled that there was a Major Samakwa, a military officer who was killed with the 3 High Court justices, who was the Director of Human Resource of GhanaWeb. He was my uncle and my guardian when I entered the University of Ghana in September 1980. I was also living with him at the time he was abducted and murdered. Was Edu Lodge chosen for my inquiry to make me feel insecure? I think so. And I continue to hold the view that there's no reason why a judicial hearing is being conducted behind the high walls of Edu Lodge. At this Article 146 hearing, no rules provided by law to regulate the fairness of hearings and trials in this country are being followed. As we all know, when a citizen is summoned before a court or any administrative or disciplinary committee, it is the duty of the committee or court to give the citizen a copy of the complaint that they are presiding over. You cannot be summoned without a writ, a petition, or a complaint. It is also the duty of that committee or court or tribunal to give copies of all documents that have been filed with them before the hearing is started. How does anyone defend themselves without a copy of the complaint that they have been summoned to come and answer to? This Article 146 committee has refused to give me copies of the petitions that His Excellency the President gave to them. They refused to give me copies, a copy of the prima facie determination that His Excellency the President is supposed to have given to them. They claim that they know that the President sent me copies on 27th March of the petition on 27th March 2025. And so they do not need to show me what the President gave to them. They also claim to have copies of the responses that I gave to the President, but they will not provide the petitioners with copies of my responses. The difficulty with this is, because they are the independent body charged with the duty to conduct the hearing, what I have in my hand from the President could be different from what they have. And I cannot assume that the two copies are the same. Indeed, no tribunal does that. No tribunal will tell you that before you came here, we know that your landlord wrote to you, so we are looking into what your landlord wrote to you about, and so that is what we will be inquiring into. They will give you what the charges are that they are supposed to be inquiring into. Second, the petition itself has not been admitted into evidence and subjected to cross-examination by me or my lawyers. In this case, because they have permitted the petitioner who has so far given evidence of whose petition we are supposed to be dealing with, Mr. Daniel Ofori, they have permitted him not to testify and confirm on oath what his petition is. There is no petition on the table. There is no evidence given by him on oath. He has not authorized anyone to testify on his behalf. So what are we inquiring into? Even though there is no constitutional instrument passed to regulate the proceedings of an Article 146 committee, Ghana has a constitutional instrument regulating the work of all commissions or committees of inquiry. This is the Commissions of Inquiry Practice and Procedure Rules 2010, CI 65. And in Article 1467 of our Constitution, if a committee is set up for the removal of a Chief Justice, the committee is supposed to, quote unquote, inquire into the petition, the answer, and the prima facie case. Therefore, we are dealing with a committee of inquiry. In spite of this, on 15th May, the committee decided, without listening to my lawyer, that it will conduct the hearing not as an inquiry, but as litigation. So they rejected the use of CI 65, which was created for the regulation of inquiries, and said they will use the High Court Civil Procedure 7. Then they decided that each petitioner can conduct his case as he sees fit. So they don't need to present the petition to them. Then they decided that the petitioners can call public officials to confirm what they themselves have not testified to. So, ladies and gentlemen, because the proceedings are being conducted as if it is a normal litigation between the petitioners and myself, their lawyers now choose and pick which part of the evidence that public officials present to put on the table. This is also in violation of known rules regarding proceedings of a committee of inquiry, because a committee of inquiry must have its own lawyer. And when it starts the proceedings, the petitioner becomes no more than a witness for the committee to prove the allegations that led to the setting up of the committee of inquiry. So the public officials who have been summoned supposedly on subpoenas without the issue of subpoenas just come and swear oaths and present documents to the committee as exhibits. The witnesses themselves do not have the petition. They do not know the allegations in the petition, and so they cannot answer questions on the petition. And when they finish submitting their documents, my lawyers are called on to cross-examine them. Since 23rd May 2025, this strange process has been followed up, and witness after witness has been called, like Nebuchadnezzar's situation, in which he demanded that the magicians in his court should tell him his dream and also interpret it. My lawyers are left to guess which allegations in the petitions that I received on 27th March are supposed to be the subject matter of the testimonies that the witnesses have referred to. Anyone who has been to the Circuit Court or the High Court and made subject to the rules CI 47 will know that those rules never conceived that a hearing can be conducted without the claims, the defenses, and the issues being carefully laid out before the parties and accepted by all of them before a hearing starts. Ladies and gentlemen, it is this total absence of compliance with all known rules of fair hearing that has caused my lawyers to file applications for judicial review in the High Court to declare all the proceedings void. Because the clear danger is that through this flagrant violation of CI 47 and the darkness of the current proceedings being held in camera behind the walls of a Lodge, my lawyers and I can come to the end of the proceedings. The evidence will show that every one of those allegations in the petitions that were given to me on 27th March is unfounded and untrue. And yet, the committee can dig up some allegation from whatever documents they claim to be having from the president, which they have not shown to me, and purport to enter a recommendation for my removal on that basis. Allow me to say that this is totally unknown in the rule of law in this country. If it was lawful, I would have no reason to alert the nation of the dangers they represent. It is the violations of law that have forced me to bring these matters out in the light of day. The final and fourth reason for this statement is that I have heard on several occasions from loved ones, persons who care, persons who may not know me beyond my public duties, and many who think that since these proceedings seem to be carefully staged to result in my removal as Chief Justice, it would be best if I just retired or resigned, rather than subject myself to an ill-motivated process. I have also received threats and veiled threats to the effect that if I fail to resign or retire voluntarily, I will be made to suffer some harm or the other. I've also heard commentaries in the media about how this process was born out of a stated political agenda to remove me and control the judiciary, and that it is a political effort that can only result in an outcome that was decided long before it started. I thank everyone who has engaged in this conversation out of concern for my safety and well-being. Let me assure everybody that I am not seeking to cling to a title or a position. However, as a lawyer of 38 years standing, a judge of 21 years standing, and Chief Justice who has served the rule of law all my working life, in fact, since I was 25, it is my onerous duty and obligation to speak up concerning anything that is extremely wrong with the administration of justice in this country. This is what I do every day. The situation I have been confronted with has shown me a model of injustice that I would never have thought possible if I had not been exposed to it. This is why, despite great personal discomfort, I have decided to marshal every effort in law and leadership to answer to this situation. Again, resigning or retiring while Article 146 proceedings are being conducted to remove a judge is not an option any judge or public official can even have. There is a decided case on the matter by the Supreme Court. The suit number is J6/02/2019. Again, no one has the authority to walk away from proceedings started by the state. Judgment can be entered against you because you fail to defend yourself. And a judge who resigns or retires would still lose all entitlements that they have worked for because they failed to defend the claims and resigned or retired while the proceedings were still going on. Therefore, if false claims are made against a judge or commissioner or other public office holder subject to Article 146 proceedings just to achieve a political agenda, the solution cannot be to resign or voluntarily retire out of frustration, pressure, or fear. You would only subject yourself to two cruelties: a judgment based on false claims and loss of everything you have worked for. It may well be that the efforts being made are intended to frustrate me so that I resign, so that the architects of the scheme can go back into the media and say that the wild and unfounded allegations were not defended because they were true and I had no defense to them. As Chief Justice of the nation, who has been given the privilege and obligation to lead administration of justice, I should not turn tail and run when I know the implications of not defending false and unwarranted charges. If I resign under these circumstances, I will be saying that this flawed, unknown, and opaque process is acceptable. It is not. Finally, let me respectfully say that the current bizarre proceedings I have brought to your attention present a twist to our nation's democratic journey that we all ignore at our own cost. My humble view is that Ghana has come too far in the 33 years of the Fourth Republic not to be concerned about the unconstitutionalities that have been designed not to affect just me personally as Chief Justice, but all judges and public officers subject to removal processes of Article 146, if this one is successfully carried out without being questioned. Behind me is every judge in the country. Behind me is every commissioner or head of an independent constitutional body in the country. If this is successful, it will be tried on anyone. I am not countering these processes for myself, but on account of the leadership burden that I carry. If the nation is willing to accept these developments in its democratic journey, it must be understood that I sounded the warning and the nation took the decision to be passive about it. I cannot share the burden of those involved in designing and implementing this enterprise of pretending to use Article 146 proceedings to remove a Chief Justice through unknown and unlawful means, by keeping quiet about the violations of law and due process. Neither can I make anyone's burden lighter by resigning or retiring, instead of proving that not even one of these wild claims in a collection of petitions is even remotely true or meets the standard required for removing a judge. Now, allow me to take you a bit of your time to walk through these petitions. They have been in the public domain for some months now. They are actually available on the internet, so I'm not addressing anything that is not known in the public space. Many negative things have been said about me through public commentary on the petitions, although the petitions were responded to 7 days after I received them. And so anyone who cared to acknowledge my side of the story would have had no need to keep repeating the petitions without discussing them with the answers. And when I provided these answers, I also added with evidence to prove that each allegation was either a lie, a wrong opinion about how work is conducted in the judicial service, a wrong opinion on the work of judges, or a wrong opinion on the duties of a Chief Justice. I'll start with Mr. Daniel Ofori's petition. It is the petition with the most claims. Only 2 out of the several allegations he's making involve him personally as a court user. In one of those allegations, Mr. Daniel Ofori is urging that I should be removed as Chief Justice because I transferred a case in which he's a party from one judge in the High Court to another. That is the crime. What Mr. Ofori did not seem to know, which I stated in my answer to that allegation, is that the judge his case was transferred from had a family crisis and had to leave Ghana suddenly for an extended period. This is the only reason why cases she was handling, including Mr. Ofori's cases, were distributed to other judges to handle. In the second allegation, Mr. Ofori accuses me of transferring a case related to the first one to the new judge who took over his case, after a petition had been sent to me to have the 2 cases heard together. Any lawyer or registrar could have informed him that it is a policy written into the rules of court to have cases between the same parties involving the same issue to be heard by one judge, so that we don't have different decisions from 2 judges on the same matter. So there is no basis of truth to the allegation that I transferred his cases to a new judge because I had an interest in his cases. Indeed, in the year 2020, I wrote a dissenting opinion in one of Mr. Ofori's cases in the Supreme Court. He won that application because my dissenting opinion was a minority opinion of 3 judges. The other 4 judges supported his application. After this, his lawyers applied that I should not sit on his cases again, because I had presided over a different case involving him in the High Court when I was in the High Court in, I think, 2010, which he had also lost. Since then, I have not sat on any matter involving the gentleman. But what is disturbing about the current Article 146 proceedings is the fact that the cases that he's complaining about in the High Court, the ones that were transferred to one judge, started from a judgment in the Supreme Court written by His Lordship Justice Kwaman in favor of Daniel Ofori. How can Justice Kwaman, who gave judgment in favor of Daniel Ofori as part of a panel of Supreme Court and whose opinion I dissented with, which has made me a target of Mr. Ofori's anger, preside over processes to remove me as Chief Justice because of complaints that Mr. Ofori has? I have already protested that there is a conflict of interest for Justice Kwaman to chair the committee trying me or hearing me on Daniel Ofori's petitions. What Mr. Ofori's allegations seem to suggest is that a court user can attack the Chief Justice and ask for the removal of the Chief Justice if the Chief Justice does not agree with his case while sitting as a judge, or if his preferred judge is unable to hear his case. And now the judge who supports his case gets to preside over the removal process. Apart from these 2 allegations, Mr. Ofori has no interest, no personal interest in all the other allegations he's making. And he should not have been allowed to conduct a litigation against me under the disguise of an Article 146 proceeding. In 2 allegations, he's complaining that I misappropriated public funds to buy a ticket for my husband and my daughter to travel with me. In answer to this, I handed over my letter of appointment to prove that in my conditions of appointment as Chief Justice, Ghana graciously gave me 2 vacations in a year. In the Judicial Service travel policy, since 2010, the Chief Justice can never travel alone for security reasons. And the Chief Justice is always allowed to travel with a spouse or another person of their choice. So traveling on my officially given vacations with my husband on one occasion and my daughter for the second vacation is part of the official conditions of my appointment as Chief Justice. I was also not responsible for buying the tickets in question, such that I could be said to have misappropriated the value of the tickets. Indeed, if the Judicial Service was not allowed to buy the tickets for my vacation, the remedy was for the Auditor General to surcharge me to refund the money. Anyone can check out the 2023 accounts of Judicial Service and know for themselves that there is no surcharge against me or anyone for the tickets that were purchased for my vacations. Ms. Ofori seems to be alleging that I should have traveled with my police escort alone on vacation and not a family member. And this is why he wants me removed from office. And I'm being tried or held behind the walls of Edu Lodge. Ladies and gentlemen, the question to be asked is, why would anyone demand that I go on vacation given to me as Chief Justice with my police security instead of going with my husband or my daughter? And how can this be a reason for subjecting a Chief Justice to a committee of inquiry? In the petition I received, Mr. Ofori also complains that my family members should not have been given per diem when they traveled with me, and I have misappropriated the per diem they were given. But anyone reading the Judicial Service travel policy will find that it provides that when the Chief Justice travels with anyone, whether police escort, another judge, secretary, or a spouse, that person is given per diem. And the rate of per diem is not set or administered by me as Chief Justice. It is regulated and administered by the Finance Directorate and the Judicial Secretary. I've already told you about the retirement of the imprest. In an arm of government where there are almost 8,000 staff that I oversee, Mr. Daniel Ofori's petition contains allegation that I transferred one member of staff to work on a different schedule, and that is why I should be removed as Chief Justice. He also alleges that I have refused to reinstate 2 members of staff whose appointments were terminated around 2015, 10 years ago, when I was nowhere near being Chief Justice, and whose issues are still being heard in court. He goes on to allege that I should be removed for terminating the appointment of 2 staff members who went through disciplinary proceedings that were initiated by reports against them before I became Chief Justice. Though it is not clear to me why Mr. Ofori should demand that the Chief Justice should be removed for transferring a member of staff or being the final authority to sign any termination letter, I handed over to His Excellency the President records covering every administrative step on these matters, supported by the due process administered by the right officers. And yet, without issuing a prima facie determination, a warrant of suspension was signed, and now I'm defending myself where there is no petition on the table. The former Judicial Secretary as Judicial Secretary when she was a judge, and so I have made her inefficient. Now, anybody who cares to know the records which I handed over to His Excellency the President was that she became Judicial Secretary in 2018. She became a judge in 2019. I was nowhere near being Chief Justice. I was appointed in June 2023. Ms. Ofori also alleges that I have appointed judges as registrars, and this has introduced inefficiency into the management of courts. Again, the records will show that the Judicial Council decided in May 2023, before I was appointed Chief Justice, that lower court judges should be appointed as registrars of the Supreme Court. So what I did was just to implement the Judicial Council's decisions. Then, Ms. Ofori alleges that a certain gentleman, not himself, but someone, who had a case in the Supreme Court in January 2024, met a different panel in May 2024, 5 months later. So I should be removed as Chief Justice. He also claims that I refused to fix an application in a case that did not involve him in Accra, which case was pending in Koforidua. So I should be removed as Chief Justice. He complains that I supervised the Judicial Secretary to administer a decision of the General Legal Council, which was taken before I became Chief Justice. So I should be removed as Chief Justice. If you read all my responses, you'll find that I provided all the records behind these decisions. Then he complains that I recommended judges to be appointed to the Supreme Court, so I should be removed as Chief Justice. Now, anyone who knows how appointments are made with recommendations from the Ghana Bar Association, the Attorney General, and the Chief Justice will know that this last complaint only shows ignorance of a very long-standing tradition It has been the settled practice for decades that in the recommendation of justices for the superior courts, it is the Chief Justice, the Ghana Bar Association, and the Attorney General who have the privilege of making recommendations for those who are to be nominated. The recommendations can be refused or accepted by the President. I encourage anyone to read the judgment of the Supreme Court in the case of Ghana Bar Association and others versus the Attorney General, 2015-2016, to Supreme Court of Ghana Law Reports 872, when this matter was even discussed, and other academic works that discuss this practice that has been around for decades. How has it suddenly become unconstitutional or wrong conduct or incompetence for the Chief Justice to recommend to the President to consider for nomination judges who, in her view, satisfy the constitutional standard of high moral integrity? Yet, despite all the evidence provided, there is a hearing being conducted at Edu Lodge. I have taken this walk through Mr. Ofori's petition to show that the allegations have no bearing whatsoever on any sensitive national issues or public safety or order, or my inability to perform my functions as Chief Justice. They also do not have any basis in law or truth. They are just an attempt to gather a lot of complaints together, regardless of whether they are true or not, whether they are justified or not, just to have an excuse for the conduct of this inquiry that breaks all the rules of fair hearing. I'll be done soon, don't worry. There's also a petition from a gentleman called Mr. Ayamga Akogo. His complaint is that on 14th November 2024, after the Supreme Court had given a ruling which went against him, I, as presiding judge in the Supreme Court, ordered his arrest without any reason. He attached an exhibit to his petition, which was a media report from a group called the Law Platform. This media report says that after the Supreme Court panel had ruled against Mr. Akogo, he started to shout in the courtroom, and that is why he was taken out of the courtroom. Essentially, therefore, his own exhibit contradicts his claims. Mr. Akogo goes on to claim that when he applied for a copy of the day's proceedings, which were signed by all the judges that presided on his case, he did not see a record that he had been arrested. So I should be removed as Chief Justice. What is significant about this petition is that Justice Puaman sat with me as one of the judges who heard Mr. Akogo's case and was named as a witness that Mr. Akogo will call. But His Excellency, the President, has appointed him to chair and inquire into this petition, and he has accepted to do so. Ladies and gentlemen, Article 1273 of the Constitution indemnifies for any act or omission by him while exercising judicial power. This provision was just last week cited as a reason for declaring a petition against a Supreme Court nominee frivolous. And yet, I'm supposed to be defending myself on the petition of Mr. Akogo for work done in the Supreme Court with 4 other judges. The last petition is from a group called Shining Stars. Searches have shown that no such group is registered in Ghana. Yet, it has petitioned against me, and they claim that during the hearing of the case of Afenyo Markin versus Attorney General and the Speaker of Parliament, when I sat as a judge, I failed to hear the side of the Speaker of Parliament before the Supreme Court made an order, so I should be removed as Chief Justice. Again, I can only point to the fact that no judge sits alone in the Supreme Court, and the court's decisions are the decisions of all the judges who sit together. So you will see that every decision I took that is complained about by Mr. Ofori, Mr. Akogo, and the group calling itself Shining Stars was done as a part of a panel of at least 5 judges that made up the Supreme Court. And all judges in the panel are indemnified by Article 1273. How tenable, if I can respectfully ask, can it be that a petition to remove the Chief Justice from office can be entertained on these grounds? Every administrative decision is supported by my constitutional obligations, and I have shown with exhibits, or I showed to His Excellency the President with exhibits that each decision that was listed was taken after due process, and yet a warrant of suspension was issued against me without giving reasons. Interestingly, there have been some recent suggestions about rules being made to safeguard judges from frivolous attempts to remove them from office. It sounds like an attempt to assure the judiciary that after unconstitutional and illegal means have been used to remove me, conditions will be made safer for those who help with it, or those who may be afraid by the current occurrences. Despite the interesting new discussion want, or stand the risk of losing everything, including their career, their pensions, and their reputations, through the smear campaigns that can accompany the process. Any petition will be enough to invoke the danger of being removed by proceedings that are not supported by law and which can be shrouded behind high security walls. I am confident that in my journey as a lawyer, as a judge, and now as Chief Justice, there is no one person in this country who can look at me in the eye and accuse me of taking a bribe to decide a case. This is the personal treasure of integrity that I live with. So what if these current proceedings are being carefully staged to result in my removal as Chief Justice, even if there's no lawful justification? All I have stated shows that any such action would have been done on the basis of lies and violations of law and due process. As a career judge who has served under 4 presidents, from High Court through Court of Appeal and Supreme Court, I could never have imagined such irregularities possible if I had not personally encountered them. I am also a mother, and I am a grandmother who must hope for better than this for our country, its rule of law, and its democracy. On my part, I chose to respect His Excellency the President's warrant of suspension, even though it was clear to me that it was not supported by a prima facie determination that is required by the Constitution and decisions of the Supreme Court. I have chosen to honor the process set in place to hear the petitions, but I do not choose to hide from the nation that perversion of law, rules, and due process, as we all know them, are driving the proceedings, and this renders the proceedings unconstitutional. I choose to trust that such darkness will not totally engulf this nation. May God bless our homeland, Ghana, and make our nation great and strong. Thank you very much. The risk of losing everything, including their career, their pensions, and their reputations.